You have a situation where your tenant is going nuts and you're not sure how to handle it. We're talking all about furious tenants. Let's get started. One of the realities of landlord-tenant law is that things are going to go wrong. And really, there's almost no way to avoid that. There's no perfect contract. There's no perfect situation where everything is expected to go perfectly. So because of that, it's important that you approach your conflict with a plan. And so the first thing you ought to think about is, do I have a plan? If you don't, you need to get one. And really, you need to have a plan well in advance of any kind of problem. If you've studied the videos on this channel long enough, you know that I talk about a 1-3-7 policy. And that plan is pretty simple. Essentially what the 1 is it says, I'm gonna forgive one default in any 12-month period. Now, it's not a requirement that you forgive one default. It's more of a limitation. Because if you're having to forgive and forgive and forgive and forgive and forgive, you're probably in a losing situation. The fact that your tenant continually violates the lease and you're having to let them off the hook just one more time, just one more time, just one more time is you over and over and over sending a really bad message. If, however, you draw a line in the sand and you don't really even have to express it to the tenant and say, look, I only give you one shot. Instead, you understand that if you're giving more than one, you're probably going down a bad path. And really, you need to treat this one forgiveness with a little bit of deference, and I want to explain. So things are really different if, say, in the second month, your tenant says, there's no way I'm going to be able to pay rent. I'm sorry, but it's going to be about 10 days late. That's very different than being in the 8th month with 7 months of on-time rent every single time, no lease violations, no problems with the property, no hassles when it came to you inspecting the property. But you have somebody who comes to you and says, look, I've got this thing that has come up. It's a one-time thing. It will never happen again, but it's going to mean that my rent is going to be late. In this situation, you might more strongly consider the one-time pass. Whereas with that tenant in the second month, that's way too early. You haven't established enough good history to justify utilizing your one pass. Don't forgive more than once, because otherwise you're probably going down a bad path. But if you're going to forgive, make sure that you've established a good history of following the lease and working well with you before you dole out that one pass. Otherwise, you're going to want to issue a notice to vacate for non-payment. So how do you do that? When do you do that? Well, that's where the 3 and the 7 come in. So the 3 has to do with non-rent related violations. Maybe they haven't cut the grass. Maybe there's damage on the property. Maybe they incurred some late fees. And you're issuing notices of default, and you always issue a notice of default. Even if you're going to waive enforcement of your rights, you're always issuing notice of default. This is an important part of the 137 plan, that you don't hold back a notice just because you don't plan to enforce it. Enforce that part of your plan every single time that you're going to issue a notice of default. Because if it happens again and it happens again and it happens again, the best way to demonstrate to a court that this tenant who pays the rent on time must be evicted is because over and over and over again you've given written notice. So if part of your plan is every time my tenant violates a lease, I'm going to issue a written notice, then you're likelier to prevent future violations. Or if your tenant just can't help themselves and they're going to violate, then the 3 says 3 strikes and you're out. Let's not also say, well, no matter how egregious the violation is, I gotta wait for 3. That's just not true. If the tenant, for example, all of a sudden decides to get 5 dogs. They're not emotional support animals, and they certainly are not in line with your terms of the lease. 5 dogs could potentially do a lot of damage on the property, especially if there's permission for none of those dogs to be there. That might be egregious enough if you've given your tenant a written notice to get rid of these animals and they simply refuse. Well, what about that 7? The 7 has to do with the number of days which you decide is the absolute max that you will wait before you get 100% of all rent and fees owed to you in a given month. If you're waiting longer than 7 days, I've seen too many of these go way wrong. Don't wait longer than 7 days. Inevitably, waiting beyond day 7 is going to have a negative impact on the following month. Because even if that rent is paid on the 10th, generally speaking, someone who's paying rent that late is never going to pay rent on time. Now, I say never, but those chances are pretty high that that rent payment is going to be late as well. In fact, generally speaking, a late payment in a subsequent month is actually later than the late payment in the prior month. So if they're paying on the 10th, you can expect the next month payment to be on the 12th, the 13th, or the 14th, and then later the following month, and later until you have this cascade of either late payment or now we're talking about non-payment because you've already skipped a month and now they're so far behind that you can't help but have to evict. But you see what's happened in that course of action is violation that you've just let slide. And the biggest one, non-payment of rent, should be addressed with some kind of notice, preferably a notice to vacate. Again, depending on the facts, you might waive it once, but don't ever do it twice. It's just not good business. So if you got a tenant that's mad and that anger is leading them to violate the lease, maybe they're so piping hot mad that they withhold the rent, or they're so piping hot mad that they're not going to follow what the lease says even after they have paid the rent. Well, you have to decide how you're going to deal with that, because their emotion is probably not a justification for breach. So when you have a plan in place and you act on that plan, you are likelier to resolve the problem, whether that means the problem itself or getting rid of the problem tenant. Now, the next thing to consider is the fact that your angry tenant may actually have a 100% valid complaint. And if they do have a 100% valid complaint, don't just ignore it. Don't just ignore it because of the way they've asked you to address it. Make sure that if your client is piping hot mad about something you did wrong or about something that you should have addressed, that you're addressing it. Now, certainly you can discuss the manner in which this particular message was expressed to you, but that doesn't excuse you from following what the obligations you have are in that lease or what state law requires from you. The fact that they're mad doesn't give you license to just block them from your phone or to stop responding to their request for whether it's repairs or some other action. Make sure that you can tell the difference between a perfectly valid request or a perfectly valid concern and something that has absolutely no basis in the law or in your lease. About the worst thing you can do with an angry tenant is to go and confront them in person. That's where things are just gonna get worse. If you go and try and face-to-face convince them how wrong they are, I guarantee you that nothing positive will result from that. But mostly, you're not going to have a record of the communication between tenant and landlord, which is why it's always best to preserve all of your communication in writing, particularly when there's a problem. By focusing on written requests and written responses, you can demonstrate to a court when the fury of your tenant has no basis, or when you did the right thing from the start, but the tenant was ultimately the problem. Don't limit yourself by only communicating orally. Make sure that your communication is in writing so that you can clearly present that to the court. That being said, make sure that you don't preserve something in writing that you would be ashamed to see in front of a judge. Your writing is there both to protect you from the tenant, but in another way, to protect you from you. Make sure that anything you transmit in writing is something that passes the Would I want this in front of a public forum? Test. If it doesn't pass that test, don't submit the written response. Now, naturally, when your tenant is piping hot mad and maybe not speaking to you in the best way, maybe not using the most polite tone, you're not excused from acting with diligence. You should still serve your tenant in accordance with what the lease requires and what the law requires. And this is less because you're trying to win them over and more because the law requires it of you. Your diligence in a matter could make the difference between them being fully justified in the court for coming after you later, or you being fully justified in saying, I did everything by the book. Your diligence is highly important with every repair and with addressing, again, legitimate or even semi-legitimate concerns from your tenant. You never want to create a position where you sat on your hands or waited extra long just because of their attitude. That just doesn't look good in front of a court. And generally speaking, a court's not going to excuse you if you fail to act diligently when you were required to. So particularly when it comes to repairs that affect the health and safety of an ordinary tenant, always act with diligence. And put aside your pride, put aside your feelings when your tenant is being belligerent. We'll deal with that later, but for now, make sure that you are doing what is required of you to, number one, maintain your property, number two, stay in line with your lease, and then number three, to make sure you do not run afoul of the law itself. However, you may find yourself in a position where you gotta evict. And the truth is, if you're having a tenant who is constantly barraging you with invalid claims or nonsensical requests, or just complain all the time without valid basis, maybe even disparaging you in some kind of public forum, maybe they're going online and, literally defaming you, you got to decide where that line is. We talked about that in the first step. And then when it comes to it, enforcement. And that's going to mean an eviction. Eventually, things are going to get to a point where an eviction makes the most sense, even if it means having to do without rent for a while, because you are better off getting rid of a bad tenant than keeping a bad tenant in place who is poisoning the water or who will ultimately create more damage than their rent money is going to benefit you. There is a cost-benefit analysis that you'll go through for sure, but if a tenant is causing problems, there's only so much you can do. And if in their anger, they're actually violating the lease. Maybe they're withholding the rent and saying, look, unless you do X, Y, and Z, I refuse to pay rent. That's a cause for you to send in a notice to vacate. Perhaps they're refusing to do something. Now, I'm not going to cut the grass until you come and fix the air conditioning. Again, you're acting with diligence when it comes to the air conditioning, but if there's no problem with the air conditioning, they're just complaining and their complaint has no valid basis. The fact that you don't go, for example, and upgrade something just because, or fix some cosmetic matter because they have that preference, is not cause for them to violate the lease on some other basis. They're holding your lease hostage on one end to demand something they're just not entitled to on another. That in and of itself is probably a valid reason, at the very least, to issue a notice of default, but ultimately may be just cause for you to evict that tenant. You can't be afraid of eviction. You have to understand that eviction might be a necessary part of your game plan. And if that's the case, you want to make sure you have all of the tools you need in order to evict successfully. Now, for those of you who are just starting out or maybe just don't have a whole lot of experience with the eviction process, I have an offer for you that we are making available to all of our clients during the month of October, particularly for those in Texas. If you have rental property in the state of Texas and are issuing notices or would like to learn a better way to issue notices and file evictions and even handle eviction appeals in the state of Texas, then you may want to check out our eviction course. There's a link in the description below, but you can also check out attorneyeg.com/eviction EV for more information on that eviction course. We walk you through the process of your notices, of filing, and even the kinds of things that you can expect at trial and on appeal. If you would like a course where we go step by step from notice to judgment to help you recover your property faster, I strongly encourage you to check out attorneyeg.com/EV, our Texas eviction course from start to finish. Again, I'm going to walk you through multiple modules. I give you samples of your notices, samples of an eviction petition, and plenty of resources along with my step-by-step training to help you file your own eviction with success. If you need more information, feel free to send us an email at info@attorneyeg.com and check us out at attorneyeg.com/EV for information on our Texas eviction course. I've represented landlords for so many years and have come to find that conflict is inevitable. There's going to be trouble between you and your tenant at some point. There are no relationships that are perfect throughout from start to finish, especially if they go on for years and years. Certainly you want to have a good relationship with your tenant, but if you simply cannot, and if that tenant is continually violating your lease, you need to have a plan in place to deal with that. You need to take effective steps to make sure that you've got a good fit, that you've got a tenant who's taking care of your rental property, and that your business is benefiting from that tenant being in place. If that's not the case, you're really going to have to reconsider how you want to proceed with this particular tenant. For additional advice on how to better landlord, I hope you watch all the rest of the content that's on this channel. YouTube seems to think that this video right here is the next best thing for you. I welcome you to watch that and anything else you find here. And until next time, landlords, happy leasing.